From item number 7 to 19.
Like to mention item number 19.
19.
Lordship.
Have you informed the other side?
The government side, I will inform.
Inform and then come. Let others mention, you inform the other side and then we.
Please, Your Lordship, I beg to mention item number 17.
You have circulated the adjournments. Or you are 18 September.
14 September, 14/9.
Lordship, I beg to mention item number 13 and 14.
All right.
Oh, bless you.
16 September.
Your Lordship. Your Lordship, I beg to mention item number 16, Your Lordship. Your Lordship,
16.
yes, Your Lordship, may kindly be pleased to pass over the matter for today, Your Lordship, as my senior is out of station.
Have you informed the other side?
Not yet.
Inform and then come.
Obliged to.
Inform and then come.
From item number 20 to 31. From item number 34 to 43. Adjournment request. Any other request?
Lordship, I have given the information to the
You
other.
have informed, you have mentioned in which item number?
Item 19.
Item number 19, as paid for on behalf of the petitioner and agreed to by the government to respond to the matter is adjourned September.
14 September.
Yes, follow.
Daily list for orders, item 1.
Item 1.
One.
17. You have given two opportunities to the other side to. Yes, the business can think of that.
Last occasion also.
Again. This is an application seeking confirmation of failure of communicate and preferring the connected appeals. All the respondents have been served. Two opportunities were given to the respondents to contest this application. However, today also, nobody has appeared on behalf of the respondent. Contest the application. I'm going to the delay of 172 days. The applications themselves, they appear to be processed and listed.
7 September.
I have less.
Item number 2.
Yes.
Lordship, I've been contacted by respondent number 1 on Lordship. We have not filed the wakalatnama as yet. Have no instruction with regard to the remaining 70.
Find out and tell us.
Yes,
Otherwise we'll wait. Have we issued notice formally?
Yes, Lord, notice has been issued.
Awaiting the service of notice.
No, Lord, Dusty was directed. We have taken Dusty, file affidavit.
But yes, Dusty is everything not here. You simply say we have issued notice.
No, my Lord, we have annexed. We have annexed the
Service of notice
acknowledgement.
on respondents and their appearance, the matter is adjourned. Your data support. Like.
19 August. Item 3.
We'll share it later. We have recorded on 2nd of April that you represent all the respondents. Is it a fact?
Your Lordship, I respect all the private.
All the private.
No, sorry, only 1, 3 and 4.
With respect to others?
Only one left. 1, 3 and 4, only 2 is, we are not.
You'll have to take first steps. Mr. Kataki. If the first steps be taken for issuance of notice on the number 2. Both means. Correctly, present request, both means.
Interim order pass earlier. There is the interim order.
Interim order, if any, in the meanwhile shall continue.
2nd September.
Published.
Item 4.
Kindly pass to the May I please, Lord? But the state has preferred an assembly for the Honorable Supreme Court. I have the records and all the compliments are responded. It is pending for consideration. It was filed on 15th of May, Lordship.
As prayed for on behalf of the respondents, let this matter come up for consideration on the date, 8 September.
28th September. Item 5.
Notice to the respondents, steps be taken, both notes and journals. First paragraph, 49 days.
23rd September. Item 6.
Wait, period. There is a delay of 28 days.
You accept notice on behalf, you are a plaintiff of the state.
Lordship.
You accept notice for 1, 2 and 3.
Yes,
For
Lordship.
4 and 5, you file requisites in the registry.
It is in 57 days delay, Lordship.
Whichever.
Okay, Lordship.
They say 28 days.
Lordship.
They'll explain for whichever day.
Lordship.
We'll see.
I'm a black.
If they are like that.
Item 7.
Since for 9 in 3 days, then the council. All are government respondents. Who accepts notice? Any junior to Mr. Gogoi? Are they state advocates? Why can't you come here, madam? You're a state advocate. We are asking, looking for a state. Forget it. You are busy doing something. Mr. Nath.
No, Lordship.
Mr. Nath, accept notice on behalf of the respondent. Or whoever, you just inform.
Lordship, I shall inform. I shall inform.
So and so accept notice. For in case any representation, any response has to do it, be filed, that will be filed within the law. Be on or before the next date. Being notified. Which you know the date is acceptable.
7 September. Supplementary list, item 44 for orders.
May I pray for a paper publication, but we have tried since long.
Where to that list? Paper publication, 2, respond number 2. On respond number 2, in 2 days, one in Assamese and the other in English. Follow it.
Kolkata.
One in circulation, one in Bengali and the other in English.
9 September. 9. Item 45 to 47.
May I please your lordships?
Yes.
For item 45 and 47, order for dusty service was not issued. It was only permitted, your lordships. Therefore, the dusty would not have been completed.
Why are you not signing?
45 and 47.
Just a minute. Why are you not signing? Please note the page.
And for item number 45, your lordships.
Just, yes, you could not do it because the notice was not issued. Same dusty notice, we are issuing notice. Thus, and we permit you to serve them dusty. We fix it.
Deeply obliged.
All the case. 16 September, all the three. Daily list, item 8 for admission.
Lordship, the similar appeal, Lordship has disposed of. We filed 4 appeals, 4 already disposed of. This is the 5th one.
Any order passed?
Yeah,
by
yeah,
you?
judgment is there. I'm sorry, Malak, I have only one copy. Malak.
In view of the composite order passed in few of the writ appeals, whereby the same impugned order in the present appeal has been set aside, comma, this appeal also stands allowed, and the order stands, and the impugned judgment stands set aside. Pura details in the mind view.
Honorable.
Item 9 and 10.
Second one.
But that is the transfer policy of the current year.
No, did we pass any order here? Yes. Yes, 1812, yes. Where is the other one?
Item number 10.
Other case? This is fine. This revised policy came in on 16/10/2025.
Lordship, that is why I'm placing in Lordship because the advisory that we challenge, those clauses has been incorporated in the policy. which we cannot challenge. We are not, no objection with regard to the policy. We only objected to issuing those conditions to an advisory or notification which was not permitted by the policy. So that was the issue in the writ petition, Lord.
That's beyond the policy.
Yes, Lord.
The advisory, I mean, we will not take exception to such advisories. Suppose the office feels, the central office, the zonal office or the head office feels that you should not be posted there. I mean, that's for administrative convenience. We would not take it as stigmatic. That's very clear.
Lordship, but the policy.
And there is only a change of place. You have not been transferred.
Lordship,
Then
now only, I'm on the item number 10, Lordship. The union challenges that how it was passed because the policy does not permit them to issue that advisory, Lordship. That is what is the challenge. Lordship will kindly come to the writ petition.
is there any, that policy, that would not be covered by any policy. Whether there is a policy of advising or policy of not advising, this is for the fair administration. In case of fair administration, if the zonal office thinks that an advisory be sent at the time of annual general transfer, nobody stops them from doing it. And we are the last persons to interfere with.
Lordship will kindly come to page 40.
But for what?
Lordship, the policy itself bars the person who issued the advisory. It does not permit him to issue that. He does not have the authority to issue. It could, Lordship, without authority.
You are an office bearer.
I'm at union right now.
You are
Because
a
I'm
union.
item number
So
10.
your member,
No, all members, Lordship.
all members. So in this case, one member, he has been transferred from one place to another.
Lordship, he has joined.
Same city, in a different branch.
Lordship, he has joined. We are not on item number 9, Lordship. Now, item number 10, Lordship. As an union, if I espouse a notification of the advisory which has been issued by an authority which is not permitted by the policy, then because now they have incorporated.
Let us see.
Lordship, in the current policy that is incorporated in the policy which we are not challenging because that is by an policy.
All right.
Lordship, that is that.
If petition number 3620, you respond. You have heard our views, you respond accordingly. That does not debar any person from issuing any directive. We will not consider it to be stigmatic. We'll say that it is for the fair administration.
But without the authority, Lord, they can do it because we are not challenging the policy which has come now because that is by way of a policy.
Whatever, this we are not interfering at the instance of the union. File your response in writ petition number 362.
And I will go till after because you have already joined it.
Yes, Lordship, that would be.
This appeal has become infectious. Dismissed as.
Kindly give it there on the second.
If Mr. Sharma is ready, we will decide it now. We are absolutely sure this is outside the scope of any policy decision. And policy is only a policy which has to be given due deference, and it cannot sit over the heads of the authorities. All right. Yeah. See, in matters of transfer, the view of this court is very strict. Unless we find it a stigmatic, unless we find that there is a malafide, we don't enter into that.
Now, it's beyond the transfer, it's a transfer policy.
Let him respond.
Oblige, Lordship. Oblige, Lordship.
Item 11.
But I'm appearing for the private respondent. Before my learned friend starts, Your Lordship, the delay has been condoned long back in January, Your Lordship. And on 18th of March, the matter was listed, Your Lordship. There it was, none had appeared, Your Lordship. But the matter is long pending, Your Lordship. My submission is that the matter may not be admitted at this stage, Your Lordship.
No, we will be hearing. Just give us 2 minutes, my lord. See, this was excise license for IMFL is granted for a year. 2 years have passed by. What is the stand of the government? Whether they have issued, they have not, whether that has lapsed, whether they will start afresh.
The LOA has been issued, my lord, which was put to challenge in the writ petition.
That we have
Beyond that, my lord, there has been
That
no,
is kept, far away from what
True,
we
my
were at.
beyond that, there has been no development.
So this advertisement was issued for which year?
My lord,
2024.
24, my lord.
For 24.
Yes, sir.
So that lapses. That's only for 1 year.
My lord.
So everything becomes infructuous.
No, but my right, my lord, which has been adjudicated
So
by this
what
honorable
will be
court.
done about it?
My lord, the issue that has
Can
necessitated
you
this.
tell us one thing?
My lord,
Now, suppose you would have been successful.
my lord,
Suppose no objection would have been raised on your bid,
My
on your tender.
my lord.
Then it would have been, you were selected and it would have been valid for a year,
True, my lord.
24 to 25.
True, my lord.
Now 25, 26 also has passed.
True, my lord.
Now, how do we restore that position now?
Now, my lord, my submission here, my lord, that inasmuch as the matter, the time might have lapsed beyond the period of 24, 25, there is one issue that your lordship can need to look into for all other future endeavors of or attenders of the excise department. The reason being, my lord, my submission for 2 minutes, my lord. I was disqualified on one criteria of my ITRs not having been attested by the petitioner. That was the ground, my lord, which had occasioned this entire writ petition on writ appeal on my part. Now, my submission on this aspect is that, my lord, if your lordship clarifies that that condition which was put in the tender could not have been enforced by the appellant. The reason being, my lord, that there is a circulation of the ITR, my lord, of the income tax department that states that a particular clause, my lord, could not have been done, my lord. That was the reason which was taken to.
Mr. Sharma, we are not impressed by the time.
My lord.
Once the issue is over, we will not open it and issue an advisory of some kind that in future tenders that shall be considered. That's not our remit. That's not our response. Correct. So now it is over. We just want a stand off from the state, whether they would start afresh. Then we say that this petition has become infructuous because of this.
My lord.
Because it lapses. Now a fresh exercise has to be done. And that way we set aside the order. We say that nothing has happened, now a start of fresh.
Because the doctrine of severability could have been invoked, my lord,
So
because
Sharma, try and appreciate.
I understand, my lord, understand, because.
Don't inject such principles which are not applicable.
No, my lord.
Doctrine of severability, this clarification, what happens to my rights? The whole cause of action for no fault of yours. The whole cause of action is over now.
It's over.
Now, can we think of a situation now? Therefore, we are arguing with you.
True, my lord.
Now, think of a situation
Absolutely correct.
where we pass an order in appeal that, well, Mr. Sharma's client ought to be given. Now, would it be a valid order, especially when the year ends
Time is left.
and there's license which is given for a year?
True, my lord. True, my lord.
So I think because of the intervention of respondent number 5,
My lord.
everything happened. Correct.
Thank you.
So respondent number 5, therefore, has spoiled your chances. His was over.
My lord. To my understanding, my lord,
The government was given the liberty to take a decision, your lordship, whether to invite a fresh
The
tender.
government would have taken a decision when that year would have survived.
Because of this,
The excise department should be represented here. We would only record one statement from him and we'll say that this appeal has become infructuous. The issue has become stale.
My lord.
And now what will happen in the next tender, that we are not going to anticipate it, right?
Yes. True, my lord. Because that has happened on many occasions. In fact, this has been a part of the recorded
I'm
judgment also.
studying the design.
My lord. Well, that is one aspect which. Then your lordship will take the matter up after maybe a short while, my lord. I'll
No, we'll finish it up.
the excise.
Without the excise department, we
Well,
Whom do you represent, Mr.?
Lordship, we are one of the tenderers in the.
Not a party in WPC
Yes.
was 1671 of 2000.
Yes, that was filed by us, Your Lordship.
It was filed by you.
Yes, Your Lordship. That was a part of the rejection of the petitioner therein, Your Lordship, was set aside and partly it was
Who appears to the excise department just for our information.
Mr. R.R. Gogoi had appeared on the.
otherwise also.
We have heard Mr. M. Sharma, learned advocate for the appellate, and Mr. A.J. Saitya, correspondent number 5, come on, the answering respondent. A tender notice was issued for grant of IMFL off-top license in Lakhimpur district, pursuant to which the appellant and respondent number 5 had along with others had participated. The bid of respondent number 5 was rejected on technical ground of the papers of on the technical ground of the tender papers not being signed on all pages. The respondent number 5 immediately questioned such disqualification by WPC number 1671 of 2024, in which an interim order was passed directing the respondent state not to issue any license to the appellant hearing, who had been successful, who had been chosen to be, who had already been selected. The issue was finally decided by the learned single judge, in which it was found that the disqualification of present respondent number 5 was absolutely justified because he had not signed every page of the uploaded tender documents. However, the learned single judge, going beyond the claim of the writ petitioner / respondent number 5, found that even the appellant as a successful bidder was not required to be given the license, as he had also violated an essential tender condition under clause 2.1, requiring proof of filing income tax returns for 3 out of last 4 years, which had to be duly certified by a chartered accountant. Thus, the learned single judge held that the disqualification of respondent number 5 herein was justified, and also directed for also directed that the appellant hearing ought not to be given the license on the same logic of not uploading, correct, of not uploading the, of not following the, of not, not complying with the provisions contained in clause 2.1 of the tender papers. The matter was remitted to the authorities for fresh consideration with the condition that from the remaining bidders, comma, if anyone was successful and would be found to be highest offerer, ought to be given the license. This court notes that the bid was floated for the year 2024-25. During the litigation, no license for IMFL off shop was issued for that financial year. Nothing happened in the next financial year of 2025-2026. In that view of the matter, the directions issued in the writ petition by the learned single judge has now become stale, which cannot be given effect to, because licenses are normally granted for 1 year. Thus, without commenting upon the impugned judgment in the present appeal, we hold that the entire case has become stale and that the excise department would have the freedom of issuing fresh tender for grant of IMFL retail off shop license in case it is required. This appeal stands disposed of.
What if one liberty may be given to the petitioners to withdraw the EMD amount security
That is
deposit, etc.?
In case the appellant and respondent number 5 would apply for return of their EMD, comma, the same may be considered, and if permissible, may be returned.
Item number 12.
Yes.
My lord, we are respondents. The
What
status.
years for the we'll take it up with item number 30.
Item 15.
May I please, the lordship? Lordship, before my learned senior begins, lordship, I would like to humbly state that I am appearing for respondent number 7. Lordship, we have filed our wakalatnama. Lordship would require a short time of 1 week to file the contract.
Wakalatnama, you are filing, we will take notice that you have been empowered by the party. You have to argue. We will not raise that objection that there is no wakalatnama on record. We will accept you as an advocate.
Sir, lordship, I would like to say 1 week time to file our counter, your lordship.
Why counter in appeal? All records are here.
Lordship, I have been instructed.
There is no cavil with respect to the learned single judge having decided that the matter is required to be decided under 127, the dispute. But then could the single judge have condoned the period of limitation, which is ironclad?
Yes.
That's the issue. Tell us what counter affidavit will you file? Not ready.
Lordship,
Don't make that plea. Take the ground of your senior. Don't say wakalatnama has been filed. We are not questioning your identity. Correct? Have you taken permission from him?
Lordship,
You knew that he was appearing. Did you tell him that I'll be taking time in this?
It was informed to us.
As prayed for on behalf of respondent number
7, lordship.
7. The matter is adjourned to interim order is there, no?
Yes. After vacation.
No, that can't be done, no?
There are other Supreme Court judgments also.
Yes, yes. That can't.
End of the day, it's a legislative prerogative, whether to provide for condemnation or not.
And we can do it here.
Decided already, I think last time.
This mistake many times is committed by us. And in case such a petition would be filed, notwithstanding the limitation running against them, it should be condoned. We do it at times for public good, but here it is not public good. It depends. If the election petition is entertained, otherwise, the person concerned has a stay for the entire tenure. Then you aspirate for sometimes in September. Interim order, if any, shall continue in the meantime.
Date?
9 September. Item 16.
Yes. Yes, Madam.
My lord,
Are you aware of that judgment of the Supreme Court?
my lord,
Then in that case, do you have to say anything?
my lord, in
Now
fact.
let's cut short the argument because that's the latest judgment if you're aware of. By Honorable Justice Sandeep Mathur. Justice Vikram. Yes.
So, my lord, in pursuant to,
Very well. All these matters shall be taken up with item number 32. Today. What do you want?
My senior is out of station.
maybe he's not aware, I just spoke to him, this he is not here.
What does it matter if your petition is allowed?
1/4/1990.
But, my lord,
Give them pension, if die, give family pension.
my lord, but the finance department and
And
administration
here is a
department
case where you recommended. It was by mistake.
finance department and
Now
administration.
there are views. Sunita Burman, and there is another case which says that something may have happened, but post-retirement, nothing can be claimed. But that view has been overruled. That the present view is that if you started, you must continue.
Here, my lord, I'm appearing for the NC Hills,
This an item number.
Where? 160, yes, right, 30, 31.
12, 16,
16, 10, 30, 31, 32.
and 30 to 33. Who all you? We will all take it up along with item number 30. Doesn't matter if your senior is not here. Tell your senior that you have argued the case and the matter has been allowed. Appeal has been allowed. Then you have no problem.
No.
Wait for your turn when item number 30 is called out.
Deeply obliged.
Item 18.
May I please?
1 minute, Mr. Tabilda.
No.
Here's who appears for the railways. What do you have? What is, Mr. Govi, you have to tell us. He has filed an application before the Railways Claims Tribunal. Yes, in deference, in obedience to the order passed by the learned civil judge. What is the status of that petition?
That petition probably,
But could you have, I mean, after taking advantage of that order, could you appeal against that order?
Lordship, here in the petition, I had three prayers, Lordship. The Lordship may kindly come to.
You have three prayers, one
Yes.
for stoppage of 45 to 60 minutes at Kamakya station.
Lordship.
Which prayer is, on face of it, it's untenable.
Yes.
This court has no jurisdiction
Yes.
direct for that.
Yeah.
That means nothing.
Then second,
The second was for direction for stopping the collecting of freight
Freight charge.
charges for Kamakya and
yes, because I have not been able, yes, I have not
until
been.
facilities are provided.
Yes.
So this will be settled by the claims tribunal
Lordship,
and other reliefs, the refund that you claimed again,
yes,
claims tribunal.
but Lordship,
So you got there. Where is the question of interfering?
Lordship, second, first then. Lordship, first and second prayer are
Stop the freight charge, we cannot decide.
two and one also, two also, because that cannot be decided by the, as part of resolution party.
We can't possibly direct the railways to do that. You can claim all damages against the railway.
No, I am not asking for,
Can we issue a direction that you please stop goods vehicle or passenger vehicle or express vehicle at particular station for this duration?
No.
That depends upon their running schedule, their decision making. We can't do that.
yes, that Lordship, that's it, that I understand, but the second prayer, Lordship. No, no, they are not stopping, now still they are collecting.
The difficulty is this, that if we make a statement, you would think that the court is without any sentiment. Now look at this. This is proving to be absolutely non-beneficial for you.
No.
This kind of contract agreement for 5 years,
Lordship.
where you're not able to load anything or unload because you can't unload at Kamakya for a short such
I
a
agree.
short period. You're not loading, and therefore you're running in a loss. That's a fixed amount that you give to the railway.
Yes,
Therefore, they were terminating the contract with you. Let you go away. Let you walk out.
no,
But can we direct the railways to stop for 40 minutes at the railway station? I mean, tell us any law.
Lordship. No,
The rail stops collecting freight.
from one way only, not I must.
Yes, you take a call.
Yes.
Direction to stop collecting freight lease. They'll say that we close this contract.
Lordship, space 15 and.
Are you happy with closing the contract?
terminate it closely. No, we have to close the contract closely.
No,
So take a call. Say that we will close the contract.
no, Lordship, that is not my prayer, because this order was.
No,
passed-
closing your contract is not a prayer. You had come before the court earlier.
Yes,
The court said that no, please don't close the
Then-
contract.
Lord,
But this is how can we direct them?
page number 59, because they have done earlier, page number 59. They had themselves done earlier, they have increased to 30 minutes at page 39, page 59. Lordship may come to page 59 for a moment, Lordship. Page 59. Now originally just page 59A, page 59. Once they have extended once they have.
The railway is supposed to be more reasonable, no? They will add to your freight otherwise. Closing the contract because you're in a very dominant position, you say close it, walk out. But is it helpful for the party, for person?
Then also, we are also facing lawsuit.
What?
Because
Then
of
you-
ourselves, so. Because lawsuit,
Make this contract unworkable.
it is now it is becoming intermediate station. Intermediate station, so we cannot lawsuit.
It is not feasible on grounds of unfeasibility, non-feasibility, contracts are terminated. Don't terminate the contract.
No.
But you can't possibly charge from him freight charges without allowing him to unload. And when the letter was addressed to you, see, this is the railway. And you're contemplating about it.
No, Lordship, may I?
Just a minute. Your friends, we are trying to enter into this.
Yes.
Not, but nonetheless, finding the conduct of the railways to be absolutely unjustified, they are doing. You take a call, otherwise we'll direct that you have to take a decision. The highest authority in the railways, which has to take that decision. Maybe SSICACQ. These are such abbreviations that we don't know. Any general manager of Northeast Frontier Railway, we can issue. Take a call. If it is not beneficial for you, terminate the contract. Or decide on this proposal. At 59A. We have heard Mr. Davildar, learned advocate for the appellant. And Mr. K. Gregori for the respondent, National of India and Private. In August 2022, the appellant entered into a 5-year contract with the railway, allowing it to operate a 24-ton leased parcel van on round trips between Kamakya station in Assam and Lokmanya Tilak terminal in Mumbai by a specific train. According to the terms of the contract, the appellant had to pay fixed freight and lease charges in advance for the space which apparently was based on the expectation of the appellant of loading and unloading parcels at stations for earning the revenue. The difficulty arose sometimes in the year 2023 when the railways extended the route of the train from Kamakya to Agartala. With this change, Kamakya station became a non-originating stop with only 5 minutes of halting time, thereby making it practically impossible for the appellant to load parcels, to load and unload parcels safely and efficient. The concern was flagged by the appellant before the railway, but the railways continued to charge full freight and lease fee, making it difficult for the appellant to continue with the contractual agreement. It has been submitted by Mr. Tabildar that an attempt was made to have the stoppage time at Kamakya station increased, which at one point of time was also done. But the time was again shortened later by the railway. It further appears from the record that at one point of time, the railways contemplated of terminating the contract with the appellant and re-auction the van in February 2024. The appellant had approached this court on that occasion by WPC number 1117 of 2024. This court set aside the termination order and the auction notice and directed the railways to create a suitable mechanism for loading and unloading of parcel as per the contract clauses. Notwithstanding such an order passed by this court in the aforenoted writ petition, nothing was done by the railways for making the contract workable. Another writ petition thereafter was filed, bracket WPC number 2170 of 2036, in which multiple prayers were made by the appellant. The prominent ones, semicolon, the prominent ones being a direction for increasing the stoppage time at Kamakya for the loading and unloading purposes. 2, issuance of direction to stop collecting freight/lease charges for Kamakya to Lokman Tilak terminal segment until facilities were provided, or in the alternative for refund of the past charges with interest and some other refund claims. The prayers were dismissed by the learned single judge at the motion stage without asking the railways to file the counter affidavit, but granted liberty for settlement of claims to the appellant to approach the railways claims tribunal. In obedience to the aforenoted direction in the judgment impugned in the present petition, in the present appeal, the appellant filed his claim, which is still pending consideration. The appellant, as on date, is aggrieved by the learned single judge not responding to, learned single judge not deciding the prayer made on behalf of the appellant to either stop collecting freight/lease charges for the Kamakya Lokman Tilak terminal segment or refund past charges with interest. The settlement of claims can very effectively be processed before the railway claims tribunal, where the appellant has already filed his petition. However, railway claims tribunal would not be able to respond to the prayer for stoppage of collecting freight or lease charges for this segment. From the affirmance made in the memo B, it appears that the entire contract has become unworkable only because of the Kamakya station becoming a non-originating stop in between Kamakya and Agartala, in between the route from Lokmanya Tilak to Agartala. Making it difficult for the railway, making it difficult for the appellant to accept parcels for unloading at Kamakya. However, it would be very difficult to compute the losses suffered by the appellant on that account, because at other railway stations falling in the entire route, there has not been any change in the stoppage time. Thus, in the estimation of this court, it would be absolutely difficult to direct for any quantified refund or prevent the railways from charging advance freight and lease charges, as that would amount to tinkering with the contract which has been signed by the appellant and the respondent. However, we deem it appropriate to direct Mr. Gogoi, learned advocate for the respondents, to take instructions in the matter, that in such an event, whether it would be impossible for the railways to increase the stoppage time, and in case the same is not possible, whether the contract has become unfeasible or unoperable. A detailed counter affidavit, as the same was not asked for before the writ court, is required to be filed, is required and must be filed by the next day. Re-notify on other course. Well, we have unnecessarily entertained this. Anyway, you tell us that it is not working.
I'll do.
Because I am able to, my contract has been operating from Mumbai. That is no issue, Lordship. I am paying from
One stoppage, if you find it unworkable, we'll come out of it.
Lordship.
If for one stoppage, if for only for Kamakya, you find it impossible to continue with that contract, come out of it.
No, Lordship, I am continuing.
the terms of the contract also.
Anyway, we have said whatever we would have said.
8.2.
Eight hours. Yeah. Obliged, Lordship.
Item 20.
What evidence will you file?
So, Lordship, today we are filing.
You have filed the affidavit.
Yes, we will file.
Have you?
We will be filing today.
All right. But you will do that only after serving him a copy.
Yes.
Mr. Nandi, you look at one aspect of the matter. We agree that the registrar ought not to have passed an order and should have been brought before the bench. But the court says that now nothing, we will not do it. So your dispossession is a fresh cause of action. That was for preventing dispossession. Correct. Just be patient and hear the court.
Yes.
Now, whether it would be profitable for you to pursue this appeal, pursue this writ petition against the order of the tribunal,
Yes.
or to approach the tribunal afresh, saying that now, even after this disposition, you please look into my mind.
No, Lordship, in surface, it is a continuous cause of action. Yes.
Please let him file.
And Lordship, Rule 4.2, which the learned,
We have
it is gone now.
It's gone. It should not have been done. Difficulty, why we are telling you this,
Hmm.
is that now that issue is over. You have already been dispossessed.
Hmm.
Now, returning, making it a status quo ante would require a different
Because,
interpretation.
Now the tribunal.
Mr. Nandi, try and understand. Even
Tribunal-
if we do it, even if we ask the tribunal to go ahead
Yes,
and not insist for dismissal of the petition. But in the meantime, whatever could have been prevented has now taken place. Now, in that case, what do you do?
in lordship, so for disposition is concerned, that is already 45 days is already over.
Thereafter, the sale certificate has been issued.
So we can challenge all these things by way of amendment, lordship. In the surface application.
The situation would remain the same.
Yes, we can challenge.
Instead of wasting your time before this court, I think we can clarify. We will see his affidavit and we'll clarify that now there will be additional prayer. That time the prayer would have been that to prevent any dispossession. Now you will say restore my possession and go afresh. It's without interfering. Go afresh and will say that please hear him out. And this time you
If
be,
your lordship
you-
directs
this
to
time
hear
you
me,
be-
that
you
that
be-
is the entire thing. Lordship, I want to hear on merit. That is it.
then you're contesting the matter on some academic issue and you don't want relief to come to you. Maybe you have a bad case before the tribunal.
No.
If
Don't
not,
have a bad
then
case.
I think don't waste time. Don't waste time.
But your
Because
lordship
you
is
are the person, just a minute. You are the guarantor, no?
lordship. And my land was.
And besides that, we have sold the property also.
No, we can challenge the sale certificate. We can.
Said that it should not have been done. Now it is open for the appellant, it's open for the writ petitioner to approach. It has become infructuous for some reason or the other.
No. We can challenge the sale certificate by way of amendment.
That we will not do that.
No, if my surface application is entertained,
File a fresh petition. Oh, that's it. File a fresh petition with the same prayer.
then in that case, lordship limitation will be the chapter.
They find your. So here, Mr. Sharma, that I can't for correspondent. Bank. Submitted. The response affidavit has been, the response affidavit in this matter is going to be filed today in the registry. With a copy served in advance to the council for the petition. Let this matter come up for consideration next week.
I'll be filing reply, lordship.
Then after 4 weeks, in the meantime, Mr. Nandi and a counsel for the petitioner may rejoin if so deemed necessary. If he may deem so.
Yeah.
If it is deemed necessary.
28 August.
Sorry, develop.
Item 21.
Here, we have come against the order by the learned tribunal, where we have been directed to pay the arrear salary and their service will be counted, their past service will be counted for the.
Yes.
But say admittedly, the petitioner not in service of the ICT from 1/4/2013 to 26/2019.
What do you have to say?
This is a case covered by the order of the Allahabad Court, Allahabad Tribunal Malot. Allahabad Tribunal Malot took aid of the Mumbai High Court judgment. Also will find it page 150. All the other person Malot, similarly situated person has been.
Now you tell us this, Mr. Kyal.
Lordship.
On merits, we don't find that the tribunal was justified in passing that order. Because it is not even a continuation of the same scheme.
Yes, Lordship.
It is just a sympathetic consideration of a person working under a scheme to be accommodated under
Yes.
the circumstances. Leaving a gap of about 5 years, 4 or 5 years.
Lordship.
Whether that should be counted for pensionary benefits and other things.
For the pensionary, Lordship, for the pensionary.
No, tell us one thing. In similar circumstances, are you computing it or not?
Lordship, for calculating their past service, it will be calculated for the purpose of retirement benefit. But regarding arrear salary, lordship, AICT is not liable to pay.
Arrears, we will say that you don't pay. No work, no pay.
Lordship,
But will you count that period for computing the pensionary benefits?
lordship, that will be probably we have to do that.
Probably. Take a call. Tell us. In that case, we clarify the order.
Lordship,
I have,
lordship,
We
clarify
are
that.
concerned with Allahabad and Bombay
that has
tribunal.
been implemented, madam. That judgment has been implemented, madam, so far Allahabad is concerned, madam.
It may have been. We will decide it afresh. We don't, that is of no persuasive value. Does it say that during this period, arrears of pay also should be given?
Yes, madam.
Then we are not agreeing to it. Then we are not agreeing.
In fact, madam, all the employees, madam, they got
This
the,
is, then if you press this, then we say that no, we can't be done.
madam, in fact, madam, in
Nothing.
all the similarly situated persons, madam, paragraph,
Be satisfied with counting of the periods of pensionary benefit. And go to Supreme Court showing this order. We will refuse with our own reason.
No.
Take instructions.
lordship, let me open instruction.
Take instructions because we would not permit this. We will say, count that period even to tell you fact. We are not even inclined for that. Because this is a different scheme altogether.
In fact, madam,
It's a fresh appointment.
in fact, madam, the first scheme came into in the year 1993.
What is your name?
Prior,
Yes,
yes, Sharma.
we have heard Mr. S.C. Kyal, learned senior advocate for the appellant, and Mr. So for the respondents. The challenge in this writ petition is to the order dated 20th of February 2026, passed by the Central Administrative Tribunal, Gauhati bench, in OA number 40/0086/2024. Directing the appellant to count the past service of the respondents for all consequential benefits, as also to release the arrears of salary for the intervening period. The respondent number 1 had been working under the National Technical Manpower Information System scheme at the nodal center of the AICTE. This scheme under which respondent number 1 had been working was closed by the end of March 2013. Thereafter, there was no engagement of respondent number 1 or others by the AICTE for several years. It was only after 6 years that the respondents were appointed, as appointed on supernumerary / ex-cadre posts with a fixed pay and grade pay. This obviously was for the purposes of accommodating the respondents who had been working under a scheme and who were rendered jobless because of the closure of the scheme, as also to take advantage of their experience in the AICTE. The respondents approached the tribunal seeking direction for counting of their past services from 1/4/2013 to 26/2/2019. Not only for pensionary benefits and gratuity and leave encashment, but also for the arrears of pay during the period when admittedly no work was taken from them and they were out of employment. They had also claimed 21% interest on the arrear amount. The appellant the office of the appellant opposed the claim of the respondents on the ground of closure of the NTMIS scheme. There was no sanction post or any ongoing scheme under which the respondents could have been accommodated and paid salary. It has fairly been stated on behalf of the appellant that there had been a proposal of another scheme, namely National Information System on Technical Human Resource, which was recommended by the Bhatt Committee. But this scheme, this proposed new scheme never became operational. Most of the respondents, it appears, have been paid all their admissible dues up to 31/3/2030, when the NTMIS scheme under which the respondents have been working had been operating in accordance with the 6th Central Pay Commission. It appears that the tribunal relying on the earlier judgment of the Allahabad and Mumbai bench directed the appellant to count the past services for all consequential benefits and to release the areas of salary of the gap period. Mr. Kal, learned senior advocate for the appellant, has submitted that the order impugned suffers from serious legal error and it is beyond jurisdiction, as it ignores the principle of no work and no pay. The tribunal has it has been argued, committed a mistake in holding that the second appointment was of the respondents was only a continuation of the first. In fact, the second appointment was under no scheme, but only for accommodating persons who were laid off because of the closure of an earlier scheme under which they had been working. However, during the course of arguments, Mr. Kayal submitted that with the implementation of such orders by Allahabad and Mumbai bench of the tribunal, the employees have been given their pensionary benefits by counting that gap period. But it would have to be ascertained whether the respondents herein be paid the salary for the period when they were out of work. He submits that after taking instructions in that regard, he shall get back to this court. We have also asked Mr. Sharma and the counsel for the respondents to take instructions whether the respondents would be satisfied with counting of such gap period for their pensionary benefits, or would they insist for payment of, the salary during that period. Earlier it was a salary, this time it is a fixed pay. How can it be continued? Which tribunal has the jurisdiction to do that? We are not following Bombay and Allahabad. If you're satisfied with this, otherwise we allow the petition, we set aside the order, you go before Supreme Court and say there also their benefits also would be taken up.
Item 24 is same.
दोनों में एक ही लिख, both the re-notify on after 6 weeks.
in September. Item 22.
May please your lordship. My lord, the present writ petition is challenging the busy season surcharges imposed by the railway authority. Lordship has previously issued notice in a similar nature matter, my lord.
Maybe if you would have been in a hurry to issue notice, but that's a policy decision, you challenge it. You challenge it, say, what is the ground for
Well,
us to say,
my lord,
busy surcharge,
busy season.
busy period surcharge.
Well,
The only ground that you have up your sleeve today
my lord.
is that they keep on fluctuating and therefore there is no certainty in the mind of the investor. Now, can that be a ground for questioning the busy surcharge which keeps on changing? Had it been static, probably you'd have made some sense. It was also removed for other articles. So these are the things on which you can you prop up your case on these slender grounds with respect to policy? Anyway, let's see what you have. Let us not stop you from making such a.
My lord.
Yeah, have we issued notice on this matter?
My lord, annexure.
Who appears for the railways?
My lord, today I'm appearing. In that case, H. Gupta appeared. Ma'am. Today I'm appearing in this case.
Today you are.
Yes, ma'am. Yes, ma'am.
Annexure 2, my lord, at page
No,
number
no,
28. Page 28, my lord. I have annexed.
Order.
30, my lord. Apologies, my lord. Page 30.
And day I may have been. Let this case be listed along with WPC, along with
WPC number 2172.
see, no, 2172.
2172.
Let this case be listed along with WPC number 2172 of 2026 on
24/6.
Very well, you are safe till then.
My lord, I'll satisfy my lord.
Tell us some good grounds for us to even apply our mind.
My lord, it was not passed by the parliament. Before it was withdrawn in
That's
the.
one ground which we will take into account.
My lord, that is the sole ground.
But the railway board has been authorized to ratify such changes in the schedule. Now, every train, every surcharge, if it is placed before the parliament has limited number of sessions.
But
now, even if see taxation policy, it says that it should be laid before the parliament. That power of the railway board to apply the surcharge, busy surcharge, that has been continuing for long, and the board is board has given that board has been given.
yes,
A Railway Boards Act also has been amended.
my lord, 199, my lord.
Anyway, you argue on 24/6.
My lord.
Railway Act. Yes,
Similar play in 23, my lord. Great.
Item 25.
If the issue here is that whether the respondent were given the benefit on the time-bound promotion scheme, whether they'll be entitled to MSCQ. Similar case has been fixed on Lordship for 17th of August. Lordship. Notice has been issued.
Give the number. Like this. Writ petition. Be listed along with WPC number 857 of 2026, which is slated to be listed on 8/6.
17.
Listed on 19/8/2026. Stop. Let notice be issued to the, how many respondents here?
Lordship, there were 35. Maybe allowed to take Dusty, Lordship. 39, Lordship.
let notice, in the meantime, let notice be issued to response number. Response number 1 to 39 on the steps being taken by the appellant within a period of 1 week, both modes. Returnable.
Some of them required
That is on 19/6. 19/8, sorry, on 19/8/2026. The petitioner is permitted to serve the respondents thusly as well. Okay, you read it. Let's see what is the next one.
Item 26.
One second. Yeah, you're ready with the matter?
Lordship, Lordship is come for the first time, Lordship, serviceable respondent of course not complete.
Service is not complete. Have we issued notice?
No, Lordship,
It's coming for the first.
for the first time, Lordship.
And just, let's see. The appellant is aggrieved by the order passed by a London single judge in response in WPC number 3898 of 2022, whereby, though the matter has been remanded to the Director of Secondary Education, Assam, for consideration of the issue whether the appellant is entitled to be made the charge principal, as he is the senior most person in the concerned school. But while remanding the matter, it was also observed that the MA and BA degrees obtained by the appellant were without permission from the competent authority. The learned counsel for the appellant submits that this makes the remand heavily loaded against him and to the advantage of respondent number 4. Next, the appellant is a teacher in Vivekananda Vidyapeeth Higher Secondary School. In which many schools have been amalgamated. The appellant had entered into service much earlier and had served different institutions at different points of time. And later, those institutions were amalgamated into the higher secondary school in which the appellant is currently working. However, ignoring him, it is claimed by the appellant that respondent number 4 was made the in-charge principal by the inspector of schools on 30th of May 2022. The claim of the appellant was that his entire service should have been counted for determining the seniority. For the aforesaid purpose, he had filed the writ petition referred to above before this court. With a grievance that his previous service in ME school before its amalgamation in the present higher secondary school was completely overlooked. Before the writ court, the decision not to make him the in-charge principal was defended by the respondent, by the concerned respondent, on the ground that the degrees obtained by the appellant were without proper permission from the competent authority, and therefore his seniority was ignored. Based on such assertions, the learned single judge, though remanded the matter, but with the caveat that the appellant did not have valid degrees. The appellant has seriously questioned such observation while remanded on grounds of same being incorrect factually, as also with respect to the propriety to be followed in judicial orders at the time of remand. Let notice be issued to respondent number 4 on steps being taken by the appellant within a period of 2 weeks, both modes returnable on so and so date. Notice to respondents number so and so, whoever is accepted by MS so and so, who shall also put in the response if so being necessary on or before the next date.
Lordship,
On date here, September 8.
in addition, I will be allowed to take justice service of the respondent.
Thus, the appellant is allowed to serve on the respondent number 4, Dusty as well.
23rd September.
Up to the next one. We'll come back.
May I please, your lordship? May I please, your lordship? I beg your pardon and apology. I was on the video call for item number 45, 46, and 47. All the 3 items are tagged together, and it was last fixed for 17 July. Justice for the writ appeal has been already completed. We are yet to receive the service. But for the other 2 writ petitions, today was listed to pass in justice order because the registry is unable to take the steps. But your lordship, my humble prayer, it has been fixed on September 6. It will be too late. Advertisement has already been published. It will be grave injustice. Kindly fix it on 17 July or any other date shortly, your lordship.
Let the service be completed first. Then make a prayer for an early listing. We'll do that.
Deeply honorable lordship. I have to come here. Deeply appreciate.
Item 27.
Please, your lordship. My lord, although you prefer the appeal, but there has been error on our part so far as the petitioner is concerned. We have prayed the wrong thing. And therefore,
What have you prayed?
we have prayed that, I must point it out, my lord, at page 203,
You're not
paragraph 16.
satisfied. You're not satisfied with the order. We might even tinker with that reduction.
Absolutely.
Absolutely.
But may I just point, I have to point out, what is against me, I have to point out.
Mr. Panik, you advise this appeal.
No. What happened is that since it was
You were
filed as-
dismissed from service.
I was dismissed from service.
And the appellate authority converted this dismissal into compulsory retirement. Oh, single judge, sorry, single judge. And look at the gravity of charge.
Correct.
You were the computer assistant
Correct, my lord,
in the bank,
lordship.
and you allowed all those areas to be.
Personal accounts and
computer
other.
assistant. You were yes, you were one of the persons, and you allowed everything to be transmitted in the account of your sister, brother-in-law. And you say that it is the punishment is harsh.
So what if I may just
Why not business? Press it and we will see.
It's not about pressing it. Like, if I just find out one thing when our error is and what I want to
We
say.
we immediately saw that you were on a back foot while
No,
very tentative.
we had prayed wrongly. We had prayed for parity with a one whose punishment was
We are not
modified.
concerned with parity. We look at your case only.
3 points. Since I'm holding the brief, I need to
I think
point out.
better option for you.
No, I'm not not quite.
I don't think you should be that adventurous. If your client is so adventurous,
Okay.
we will restore the punishment to dismissal.
No, I'm not pursuing the matter to that extent.
We were surprised as to how this was done for no good reason. No good reason. I mean, we are not stopping you from arguing. You argue,
No.
but we are only forewarning you. This is not a threat. This is not kind of. Who appears for the state would be advised to file a cross appeal.
No.
Yes, well, I should do that.
Ms. Sharma is waiting in the wings. She'll take time for filing the publication notice. She'll take time for filing a cross appeal. Don't press this, Mr. Panik. That is not advisable. Withdraw this petition after some arguments. Or we dismiss it.
So we'll withdraw maybe on the next date so that we can have the clients review it and then we review.
Why take clients?
Right.
Let us deal with it. The client is
Since-
giving
since-
client
we
is
withdraw
giving
it.
instruction to pursue this case.
No,
Argue
we'll
this case.
withdraw. So I'm on
One line.
I understand. So we're not pressing the matter any further. We're not pressing that whatever we got, we got. Since we're not doing that thing, not.
Tomorrow. As prayed after tomorrow, as prayed for on behalf of the appellant, let this matter be listed on so and so. 76. Now, on that day, we have shown you, we will, if you receive instructions to argue this case on grounds of parity, we will hear you. We are not going to stop you from making that. Don't you have initial view?
Ready.
Item 28.
Bad logic. Also, I'm paying for a thing. May I block it?
1 second, sir. Well, you want time?
Yes, Lordship. Only 1 in 10, Lordship. I'll take the instruction from my client, Lordship. 1 in 10.
Instruction from the client with respect to what?
Lordship, some documents will be provided in my client. Some documents will provide. Only 1 in 10, Lordship. Next week, any of the day, Lordship.
Mr. Chakravarti, you are appearing in this matter.
Attend for 4 times 16.
Whether he has some ground or not, we don't know. We will be examining. But could it have been dismissed only on the ground of, no fresh calls? Once it was withdrawn. Second time it was filed, no fresh call. I mean, especially land acquisition compensation.
I mean,
If he has
he
no
has already
ground,
received the compensation. That
he has received the compensation.
that was the
Where is
affidavit,
that statement?
my lord, that was the affidavit filed by the government. We had released the amount, the amount was received by them. Faced with that circumstances, my lord, we withdrawn the appeal. And then court has granted him the liberty. Okay, if there is any fresh cause of action, meaning thereby,
No.
if there are some persons who have referred from the
Yes, now what do you want?
Sorry, not.
Mr. Das, now you tell
My
us.
friend, my friend, Lion Council says, Lordship, the amount has been received, Lordship. So concern not a single penny I have received, Lordship. But concern is, Lordship, the phrase cause of action, Lordship. So whatever order.
When is that affidavit?
Minor. That is not enclosed here, my lord. I'll bring all those on the copy. If you mind, I'll bring.
Is one of them, Lordship.
Mr. Das, we don't leave like this. Many times, filing of a writ petition or appeal can prove to be vain. Now, in case it is found that you don't have the documents, we'll say that your client is then trying to overreach the orders of the court or trying to mislead.
No, Lordship, no. Lordship, we record that.
Have you made that statement that on behalf, before the learned single judge, it was argued an affidavit was filed that payment of compensation has been made? You may or may not have received it.
No, not a single penny I have received.
No, but have you said that? When you were so,
Lordship, so Lordship, whatever.
why did you withdraw that petition? Which document did you want to annex?
So Lordship, they have no file, Lordship, from that. Lordship, 1 week.
How are you so sure that this court will grant you time? You have not circulated the adjournment slip.
So because Lordship, some instruction will be required, Lordship. Very important,
Very important.
instruction will be required, Lordship. So that's the Lordship.
No, but how did you know that time was granted by the court when you have not
So Lordship, any of the Lordship, by tomorrow, day after tomorrow, any of the day, Lordship.
No,
Will be respected.
we don't give you the time at your choice.
Day after.
We were initially inclined to interfere without knowing this background. And therefore, rightly, the single judge has said that what is the fresh cause? We were contemplating of a situation where, because of the land acquisition being an old one, you were not paid, therefore you have come. So that way, the Supreme Court says, I remember of a situation when I had dismissed the petition on that ground. After 40 years, Supreme Court remanded it, said that no, these are important rights.
So what we do respect of it, initially petition, there are 3 respondents did not
As
append it.
prayed for on behalf of Mr. R.C. Das, learned advocate for the appellant, seek some time to bring in, to bring in certain important documents which inadvertently has been left out while drafting the appeal. Let this matter come up for consideration on your date in September.
23rd September. Item 29.
This is against the matter passed by the administrative tribunal, but interfering with the punishment imposed in a disciplinary proceeding.
One second. Can you just give us 2 minutes?
My lord.
What was charge number 1?
My lord, the charges are at page number, my lord. 51. Charge 1 was that you so and so while posted and functioning as senior accounts officer under general manager Kamrup in the year 2009-10. My lord.
What was, just tell us what was the charge?
My lord, that the e-pins that were to be issued.
Supervision, negligence, and lack of devotion to duty.
My lord.
Which out of the 3? Which was found to be true? Lack of devotion to duty or violation of order?
My lord, violation of my lord, basically the statutory procedure that is required to be followed, my lord, in issuance of e-pins, my lord.
Now this paragraph 20 will go.
My lord, para
Paragraph
20,
20 will go.
my lord, that is what we are saying, my lord. Because this is a minor penalty, otherwise that can be imposed under the concerned rules also.
Yeah, we keep on. But we,
But coming for the first time today,
that's
notice,
20 and 20. First time, that's all right, but then
notice is still.
notice. Now we'll record our findings today.
My lord,
Tentative finding, we
My lord.
always do while issuing notice.
my lord.
Rarely do we issue just notice like that. We have heard Mr. B. Pathak, learned advocate for the petitioner slash Bharat Sanchar Nigam Limited and two others. The respondent, while serving as a senior accounts officer in the office of the general manager, Kamru, Gauhati, was subjected to a disciplinary proceeding with respect to a mismatch in the electronic recharge PIN of smaller denominations. In the stock and the accounting, resulting in loss of approximately 17,27,000 to the organization. The respondent was charged with failure to exercise proper supervision, being negligent in discharge of official duties, and violation of conduct, which was violation of the standard conduct which was expected from a senior accounts officer. Out of the 4 charges, 3 were not proved, and 1 charge was proved. The disciplinary authority, disagreeing with the inquiry officer's findings, issued a disagreement note to the respondent. And after receiving his reply, found that the appellant was guilty, responsible for the misconduct, and slapped upon him a major penalty of reduction in the pay by 2 stages in the time scale of pay for a period of 2 years with cumulative effect, along with recovery of rupees 6,67,250 from the respondent as his share of the pecuniary losses suffered by the organization, suffered by the BSN. In departmental appeal, there was a slight modification of the punishment. And it was directed that after the expiry of 2-year penalty period, the reduction in pay would not adversely affect the future increments. Not satisfied with this, the respondent challenged the appellate order before the Central Administrative Tribunal, Gauhati bench, by OA number 316 of 2017. The tribunal, by the interim judgment dated 25/6/2025, so upheld the disciplinary proceeding being free of any procedural infirmity, but further modified the sentence, held that the liability for the financial loss to the BSNL was required to be attributed to the franchisee, namely Messrs. First Choice, who should be asked to indemnify the BNSL for the losses. The net impact of the aforementioned judgment, which has been questioned by the BSL, is that the respondent has been relieved from the burden of recovery, burden of payment of ₹6,67,200. Mr. Pathak, learned advocate for the petitioner, submitted that the tribunal has exceeded its jurisdiction by imposing penalty on a third-party franchisee who was not even party to the proceedings. The tribunal had been called upon by the respondent to decide the dispute between the respondent and the petitioner/employer. Whereas the franchisee, namely Messrs. First Choice, is only a private contractual entity, not an employee of the BSNL. So the tribunal thus, it has been argued, has acted beyond its statutory jurisdiction by adjudicating the liability of a third party, thereby relieving the respondent of his responsibility of making payment of his share of the loss caused to the BSNL to the tune of 6,67,250. Let notice be issued to his respondent number.
Sole respondent.
Should to the sole respondent on steps being taken by the appellant within a period of 2 weeks, both modes returnable on 8th September.
14 September.
In the meantime, we don't intend to stay, otherwise, the petition would, this petition would actually be allowed that.
My lord. I have not prayed for stay also as such, because recovery was initially stayed by CIT. Now it has been set aside. It has to be restored now.
Normally, we find the order to be what interfering, we put a stay order, but when here it is not required.
Okay.
Yes.
Item 32, 33, along with item 12 and 16.
Mr. Nayak, you have to address this court with respect to all these.
Yes, that is okay, Lord.
I think you can just check a principle would be decided. Otherwise, every petition would have separate set of facts.
Yes.
Just find out today and we hear all these tomorrow. Tomorrow is the day fixed for hearing.
Lordship, may I pray for Lordship? Lordship, I have already prepared the matter, Lordship.
Some more preparations.
Correct. Not all.
If lordship permits, lordship may take up this matter after vacation, lordship. Immediately after vacation.
No, vacation, that will be difficult. You can choose in time before vacation. You choose your day.
Already.
Just a moment. Choose your day before vacation. I think you have about
25th, lordship, it's Thursday, lordship, hearing that. 25th.
25th of June. It is a Thursday. I will hear you. Do we fix a time?
Lordship.
Again, all these matters, the list will. Yes. Shall we list as let all these matters be listed. For 25th of June. For final decision.
Lordship, another matter is there, item number 12, lordship, that is an appeal filed by the state, lordship, more or less similar matter. Lordship.
12 also.
12 and 16.
12, 16, 30, 31, 32, 33.
Apply.
All four. See, you examine that judgment and tell us. Talk about the cutoff date. Now we are bound by what the Supreme Court has said.
Yes,
Sugandhu, what is in this case? Well, they have no case at all.
Is he entitled to argue or not? Is he entitled to argue or not? Tell us.
That will be fixed, that already fixed.
So you examine that judgment. Let us know under what authority will we differ from that. And if at all we can. And you'd also talk about that cutoff date. What is the cutoff date? You'll have to examine it on a limited aspect, I believe, with that judgment. Only because of that judgment. Otherwise, you have many points to add.
Lordship, on last date also, I submitted one line, lordship. Many judgment may be placed before your lordship. Ultimately, it's for your lordship to decide the precedential value of a particular judgment.
The last one. The last of the judgments that we have referred to. Just go through that.
Including the last one.
Include.
Yes.
All.
Obliged, lordship.
Item 34.
Yes.
My lord, we have issues from instruction.
Have you shown a copy of this, the communication to us, please? Now, without showing it to us, why do you have to give it to us? Now, something is being done, madam. Let's see.
Lordship, we had already submitted a draft of the rules. Lordship, department had contacted us to draft the rules for caregivers. We have done that, we have given it, but after they gave me a call after Lordship fixed up this matter. They wanted me to come and again give them the draft copy. I think they misplaced it. So, we sent it
They asked
across.
for the draft
we-
rules and they misplaced it.
We sent it across, Lordship. Now, according to the meeting we had with the department, it was that the university would start a course in all the
By what
medical
time- by what
colleges.
time, Mr. Bora, can we expect?
My lord, the time has not been stipulated by the department. Anyways, can it be after vacation, my lord?
Lordship, my limited prayer is, Lordship,
I think it's August, sometimes in August.
Yes, my lord.
we have already pursued it with the department since nothing was happening. So we are before this court,
It
Lordship.
is bearing fruition. I mean, the
Yes,
efforts have started bearing fruit. Now that we are looking to it,
Yes,
let's give
Lordship,
them some time.
that is a significant change, Lordship.
Yeah, for the respondent state, let this first week of September. In the first week of September, it will be next.
Lordship has fixed it for?
First week of September, we'll fix a date. We'll looking at the calendar.
Lordship, can it be on before the 19th of August, Lordship?
The 19th, before 19th of August.
Anytime on 19th is also fine, Lordship.
19th of August.
Yes, Lordship.
No, we are fixing it in first week of September. August would be too early.
Lordship, can I have a copy of this instructions, Lordship?
Please,
Yes,
keep a copy.
yes, my lord, I have.
2/9,
Much
2nd
obliged.
September. Item 35.
Are there other matters?
Lordship fixed on, that is, this criticism fixed on 17/8, Lordship.
It was the order.
Leading one is 5222.
See, orders. Under what rule they convert the 20% like limits into 2024?
The leading one is 5222 of 2020.
No. The special leave to appeal is pending.
Oh, yes, Lordship, that is Lordship.
Yeah,
3680 of 2025.
No, in view of the special,
This one, Lordship, specially appeal.
still pending.
Still pending fixed in the first week of August, Lordship.
Special leave number 3680 of 2025, pending before the Supreme Court with similar issue. Let this case be listed on 17/8/2024.
Item 36.
In this case, also my raised. So I required one more.
We will give you time, but look at this. You had permitted the purchase.
No, your lordship, that document is disputed and it has been sent to FSR in that yard.
Okay. Alright. And the district magistrate's order also is fictitious.
Yes.
That order also is fictitious.
Magistrate order.
Where have you proceeded for taking him into custody and lodging a FIR against him?
Your lordship, that the entire thing is that NOC only, and that has been without any registration number, your lordship. Bank,
There were proper NOC number one permission from the bank. The bank was in possession of that mortgage property. You said that go ahead. We are not proceeding.
Yes.
And you cannot be Mr. Sharma. You got him, you asked him to deposit the price of that property in the loan account. Didn't you? All this is false.
no, your lordship,
No,
deposit is
tell
not
us one thing.
false.
Was it deposited in the bank account or not? Loan
Yes,
account or not?
It is deposited.
And then what are you disputing?
No, your lordship, but.
Return that money.
Your lordship.
Proceed against it. Return that money to him. You can't be, I mean, you're not being a Shylock, you're being the father of a Shylock. And then we will have serious doubts about your bona fides. Your bank,
Yes.
bank's bona fides. Probably the branch manager did not agree to what he was offering. And you be very careful in filing your reply.
Yes, sir.
One fact, hinges, one fact would turn the table. One fact.
Yes.
That you permitted the amount, the purchase amount to be deposited in that bad loan account.
No, at that time it was not a bad law. your lordship.
And in that earlier DRT also, they have not raised this question that the document is forged.
No, it has been raised. All the affidavits.
Be very careful in formulating
Yes.
your reply.
We have filed an original
We are not
application.
we are not concerned with his property. We are concerned with the conduct of the bank.
Yes, sir. I understand.
Has prayed for. You go by the end. Okay. This matter. When do you want it?
But just application.
You have already dispossessed him.
Yes. sir. One more
Lordship,
property.
After 1 week, maybe just before, yes, 24, 25.
Immediately in the first week after the pay. 13th, 14th of the month.
Yes,
14th.
You will serve a copy in advance to him.
yes, sir. Without service, your lordship is still not accepted.
Item 37.
Lordship here. Lordship directed the NCLT to dispose of my application.
They have not done it.
They have not done. Lordship, they are taking some other issues. Lordship, out of record, Lordship, I was sitting with the members. That you should, why you have approached honorable court and court is not, why you have approached, I thought. And they're taking the issue personally. Lordship. And my prayer is Lordship to direct the NCLT to dispose of my application filed under section 95 for jurisdiction.
I shall leave it to your lordship. I cannot say. Because it's a direct matter.
Where is that other order that you have passed?
Dear order, Lordship, page 125. Property part is page 130, paragraph 17.
Request here. You respond. We don't want to lock horns. We don't want to lock horns with the judicial authority. Had it been administrative authority, we'd have straight away summoned them here. We don't want to do this. And Mr. Kyal would not be able to write it on the affidavit.
Lordship,
This
correct.
is the objection. Otherwise, you will immediately initiate a proceeding against them. And you know of a situation when it had happened. But it had happened in Supreme Court, where the Supreme Court had called the member of the NCLT and said that you resign, otherwise we take you into custody.
Not.
Do you remember?
Yes, your lordship, in the DIT matter of law.
Do you remember that case?
Yes, your
Show
lordship,
that
it's in
case.
DIT matter.
Show that
That
case
is
to
also
your
has
officer.
been found.
Show that case to your judicial member. Well, do appeal, Mr. Secretary. Unnecessarily, your case shall be spoiled. Let us see. The only difficulty with us is why we are not interfering at this stage is that the Supreme Court has very clearly said that this is no adjudication.
Yes.
That is the only thing which is holding us back. Anyway, you make an oral prayer before the judicial member and say that despite this, the court did not pass any order saying that he's a judicial member. We are respectful to him as far as possible, but decide my issue simultaneously. It is no adjudication. We'll grant you time. Deal with it tactfully, otherwise we'll deal with it.
Lordship.
The only thing which is coming in our way is not our laxity in passing an order against a judicial authority, quasi-judicial authority. Because the law says that this IPC section 95 proceeding is not it's not an adjudicatory proceeding.
Lordship.
It can go on simultaneously. Anyway, we are adjourning it. Let's see what they do on the next. Resolution professional has been appointed
Yes, your lordship.
Let us not behave in that rigid fashion as your judicial member has done. We'll see it after the vacation.
Not.
Let's break for the department.
Mm-hmm.
16 September.
Next, 38, 39, 40, Mr. Chanda, you're ready?
Lordship, in this case, I am required to find an affidavit. That
No, no,
was
no. Where is Mr. Chanda? Ask.
My lord, I am appearing.
Yes, Mr. Chanda, if you permit time to him. I
No,
think you have argued.
They have
for this.
filed, they are filing the affidavit today itself.
No, it was fine, but there was some defect. 2 pages was not legible. I will rectify it.
And
by
apart from
tomorrow.
that, my lord, the vacancy position, as your lordship have called for, that is given only in respect of one writ petition.
Just a minute, Mr. Chanda. Think about it. Let him issue the key. Otherwise, refuse. Don't say that no time. Then we will not have. We will cancel that. We'll come back. It depends on you, Mr. Chanda, whether you want that affidavit to be filed. We'll come back at 2. In the meantime, you ask Mr. Chakravarti to give you tea and some goodies, then you agree to his prayer for adjournment, we will also.
Only one thing. I have got a copy. There, your lordship asked to show the vacancies, that was clapped subsequent examinations. But they have declared the vacancy position only in regard to item 39, not in regard to item 40.
We don't remember so many facts as you.
My lord.
Mr. Chakravarti learned CGC submits that. Rejoinder.
No.
A rejoinder.
No, one
An
additional.
additional rejoinder affidavit. Additional affidavit is going to be filed today. Be there for seek some time.
No, by tomorrow, Lordship, because 2 pages has to be rectified.
By tomorrow. Mr. M. Chanda, learned advocate for petitioners. Pura तीनों में एक learned advocate for the petitioners. Learned for the respondents. Does not have any objection to the. Does not have any objection. Let these 3 petitions be listed for consideration. On 15th of July. Next.
Supplementary list, item 1, matter pertaining to Kohima bench.
Yes.
Yes, may I please, my lordship, lordships. I have received a objection filed by the respondent number 1 to 7, lordships.
Yes, what do you have to say?
Lordships, in your opposition, evident in opposition, paragraph 3 and 6, they have pointed out 2 points.
Yes, we are not finding any good ground to review. We understand there have been.
Lordship,
Yes, what do you- Yes. Yes, I mean, can you tell us your name?
Lordship, Subhumati Lordship.
So what do you have to say?
Lordship, here in the counter affidavit filed by the state Lordship, they have stated 2 points, that is at point number 3, they have stated that at the time of the retirement, I was in cell number 17. And then at paragraph 6, they have stated that this Honorable Court had passed direction and read appeal 2, 3, 4, and 5 to show some employees who have been regularized post Nishivi. Accordingly, I have annexed in my review petition. And then in your statement in batch 4 of your paragraph 6, they have clearly stated that this all was done in line with the direction of the court's order. So, Lordship, here my only reply to that 2 points is that firstly, in the year 2014, I along with 2 petitioners were released from services. And then that 2 particular employees were much more junior to me. But then, yes.
Correct. That we have taken note of
Lordship.
in our judgment which is under review.
Lordship.
We have said that.
Lordship.
If you come to paragraph 20 of the judgment,
Lordship.
it appears that perhaps strengthened by the aforenoted judgment, the widow approached this court on finding that 2 persons junior to late employee had been regularized. However, what was not noticed by the respondent was that such regularization was after the husband of the respondent had retired and had also left the world of living. That fact, therefore, would not control the case of the respondent who had not attained the sufficient seniority to be accommodated on a regular post, and also that no vacancy was available in that category for accommodating the late husband of the respondent. Now, these 2 persons, they were junior to the husband of the review petitioner, correct? There can be no 2 opinions about it. That is admitted by the state. But then when they attained their seniority after the death, then they were promoted. So can that be a ground to review?
Lordship, on that, Lordship, I have only one submission. Rights to be considered is already been accrued during his lifetime in service, and this right cannot be defeated due to his death, Lordship. And then cause of action survives to his legal heirs as it involves service benefits, Lordship.
I don't understand this argument.
In Nishibi's case, the petitioner died while in service, whereas in my case, Lordships, they have utilized my service till 35 years of age, and then my rights to be regularized have been accrued well in service,
We
Lordship.
have all sympathies for the widow, but the difficulty is that we can't pass an order. This is very difficult. You know, see that when he died,
Lordship.
that he had his seniority. I mean, his case has not matured for regularization, because according to the government circular of Nagaland, there is a list in each of the department of work charged employees, and as in when the vacancy arises, they are to be accommodated. Now that situation never came when your husband was there.
Lordship.
But after his death, vacancy arose, and 2 juniors thereafter got promoted. Can you liken it with the other cases where a division bench of this court has passed an order that you should be considered? We don't say that your rights have been extinguished, but this is a situation where no, I don't think it will be arguing the same thing over and over again. Can be entertained.
I understand. Lordship, with regard to that, I'll take you to Annexure 7, page 120, Your Lordship. Relevant part is page 123, where this honorable court is given direction, Your Lordship. Page
What-
123.
I think the better option for you is to go to Supreme Court and invoke Article 142 jurisdiction. We can't do it.
Lordship, my last submission, Lordship.
Yes.
Similar statutory employees who were again appointed after me, Lordship, who were retired after me. Post Nishivi, they have given regularization which I've enclosed in the review petition, Lordship. And then with regard to that, may I take you to page 59 of my review petition? This is the rate appeal 35 of 22. Page 59, paragraph 26, the relevant part, Your Lordship.
See, if this were the case, if this is the interpretation by the division bench,
Lordship.
in fact stands on a different, background. Now, this is, if this were the case, then no person junior to any person who has been listed as senior in that circular, in that list, would ever get promoted unless these persons even posthumously are accommodated. The difficulty is this. Now, with the grant of pension to the widow of such a person, that seat gets filled. We can consider.
Lordship, here in
Here you on some other day, let us supply our minds. How can you be helped? Because there are 2-3 judgments, division bench judgments, which are in at variance with what we have decided. Let's see what we can do.
Lordship, I have 2015-1 ACC Lordship in the case of Uttar Pradesh and Arvind Kumar Lordship.
All right, we'll hear you on some other day. Let us have a deeper look of this.
Lordship.
Prima facie today, we don't think it's a case which can be argued in review. That will be re-agitating the same points. But then we quite see that there are 2 division bench judgments which are at variance with what we have decided. Let's see what we do. If we refer the matter to a larger bench or we decide that it is no space of review, you go before the Supreme Court. Let's see, we will give you one more hearing. Let's see. Mr. Shukri, you also get ready on that.
Otherwise, Lordship, here the petitioner, he has not made out any case for review. None of the grounds for review are ever pleaded.
We understand that. He also, the learned advocate also would understand that. But here we are concerned with another issue. There can't be 5 different judgments operating in the same field. Now we have to do something about it. This review we will not do, but we might consider referring it to a larger bench and then we will decide what is to be done. The better option for the respondents would be, for the review petitioners would be to approach the Supreme Court. But let's see, we'll give you one more hearing.
Lordship.
Again, as prayed for on behalf of the party, let this review petition be listed on. We'll give you a time after the court reopens, sometimes on 14th or 15th of July.
Lordship.
15th of
Much obliged.
Not on the merits of the case, but you have been able to point out 3 judgments of division bench which are at variance on principle. We might have to reconsider that aspect. Mr. Shukri, you also examine those judgments which he has referred to.
Lordship.
And the judgment which we relied upon, that has been held to be per incuria sometimes by one of the benches. I don't. Earlier. We'll see.
Lordship.
All right.
Daily list, item 41.
Yes.
Under this contempt petition, the operative part is at page number 230. We have filed our rejoinder affidavit.
Where is the review petition pending?
And regarding this case, there is no review.
Review of the original judge.
Yes, ma'am.
Where is that pending?
Pending before this one. I think it is
Let
immediately
this
after.
case be listed along with review petition number 15 of 2025.
My lord, there is several case pending in Supreme Court. That's why the review petition is not here.
Let them say that on the next day. Then we will consider.
Moreover, my lord, this case,
If the matters are pending before Supreme Court, we will not issue any contempt notice.
this matter is separate from that matter, my lord. Those matters were.
Let's see.
That's why I'm saying, let the review be listed, then everything will be good. Review is not something.
All right. Let this be listed along with review petition number 15 of 25 on
There is a fixed date, madam.
first
in
week
that
of
matter.
September. The second of July. Oh, really? On 22nd of July.
Obligation.
Item 42.
Lordship, yes. Yes. 1 second. Yes.
Lordship, before my learned friend starts, may I
No,
just-
she doesn't require to advance the argument.
just,
You tell us how,
yes, madam.
how do you defend this order
I-
passed by the tribunal?
Right.
Now,
Before that,
Mr. Pukin,
sorry,
we are only limiting you to a
yes,
space where you have to advance your argument.
yes.
Now, the tribunal for all, let us not get into those details where the tribunal committed an error to our understanding. That order goes, that is without cavil, without question, that order goes. The question is that let us handle it differently. Now, the transfer order in the year 2022 was questioned and that challenge was sustained by the tribunal on the ground that within a short span of time you have been transferred. Now that period also is over because of the interim order of stay. Now whether it stands today, should you not be transferred again?
I will,
Now this is the space within
I-
which you can fling your.
grateful, grateful.
Now we are not indicating anything else in the order for the reason that we have not been called upon, but you should have been transferred then. There should have been no stoppage.
I'll
Now,
address.
otherwise, this is the standard procedure. If you're facing vigilance inquiry, if you're facing CBI inquiry, you are taken into custody. Your remaining in the entire zone was difficult. Now, with the railway board having approved of that transfer, yes, there was no business for the tribunal to have stayed the operation of one.
I'll try to satisfy.
This is
I try to satisfy. Absolutely. Before that, before I proceed, I have handed over 2 copies of indexes to your lordships. On the first occasion, my lord, when the writ petition was filed and notice was issued, the copy that was served to us had 2 different IAs. The OA that was initially filed was 152. When the copy was served, my lord, we have filed now a response to that, bringing in record the OA 152. Subsequently, on the last occasion, my lord, there was some kind of discrepancy on the papers and in the numbering of the paper book, and there was a direction to serve the copies to us again. On that, my lord, what has been now served is a complete different set of petition, along with an OA, which is a second OA. So we have now practically filed a reply to the first writ petition, but the second writ petition, my lord, we have not even filed any reply to that. Yes, because there are 2 OAs that we have filed, my lord. The second OA is.
Forget about.
I only wanted to point out that.
No, let us see the order.
Yes, ma'am.
There is no.
Yes, I'll come to that. I only wanted to point out because in practically speaking, my lord, in regards to the writ petition that has been filed before the petition that has been filed, my lord, no reply has been on record.
Where are you posted at the moment?
I'm not posted. I'm here. I'm in Gauhati as of now. I have not gone and joined.
Maligaon.
No.
The tribunal has not finally passed an order.
They have. I tell you what happened. When the first order was passed, my lord, there was an order.
Tell us the first
No,
order.
we are just confining only that period, my lord. There was an order that was passed, which your lordships has rightly pointed out. You know?
Why are you agitating on that?
No, I only want to
have 3 years passed.
Yeah, from the time of passing of the order, yes.
And otherwise, you have stayed at this place of posting for how many years now?
I was first posted from Agartala after the recommendation from the vigilance. I was transferred, my lord, from Agartala to Maligaon.
You never went to Bihar.
I never went to Bihar.
We are setting aside this order. We are free to transfer you anywhere.
My lord, may just only hear me once on one aspect. That's all I'm saying, my lord. In the order that was indicated by the vigilance was to transfer me to a far off place. That order was complied. I was transferred in the month of July. After being transferred in the month of July, I was then indicated that because of the CBI trial which is pending, you now need to go out of the zone. So the out of the zone has not been identified by vigilance. So my transfer happened twice. 19th of July, I stand transferred, my lord. After that, they again transfer me. Now they say, because of the pending.
Do you have any right to stay at that place?
My lord, I understand that.
We have understood your right.
Right.
And therefore, we are not even taking seriously your
reply
that OA and other things that have not been given. You have replied differently. Forget about that. Now, today, what is the situation? Do you have any right to remain glued to that position in that zone?
In terms of in that regard, may I just take to the observation that has been made by the tribunal, my lord? Only one
that
paragraph.
argument also which you have made does not appeal to us.
My lord, the reason I'm saying is because
you are supposed to go out of that zone for the reason that your presence there would not be good. You would have contact with the contractors. You were first sent to a non-sensitive post.
Correct.
You agreed because it was in Gauhati.
Right.
Now they found that this is also dangerous. Now, if you ask us that this is stigmatic and bad, we have our own reasons to say that because it is the standard procedure in such cases. They go for such advisories. And railway board, have you questioned the railway board? Did the tribunal look into the railway board's recommendation?
My lord, the railway board only recommended based on the letter that was issued.
Why do you get into this fact, Mr. You're an experienced counsel. You want us to record things against you.
No, my lord. I'm only saying this, my lord. The transfer order that I challenged, my lord, I challenged on the ground that I was transferred twice in a span from July to February 2025. And I said that my transfer, if it is based on the CBI, the vigilance opinion, has already been done. So let me stay here. NF Railway has a very big zone. I could have gone anywhere. If it is a question of my presence in Gauhati being questioned in grounds of my integrity, my lord, I could have been sent to Kathiawar. I could have been sent to any other place. But they recommended out of the zone, which was not the vigilance opinion. Vigilance say you send him far away.
I have gone from Maligaon. I could still understand. I mean, Gauhati, my lords are right. I could still be an influence to the others. But there was a big zone available, my lord, to me. Till Katiha, anywhere else, my lord. That's only I'm saying.
Not at all. You can't have a choice. You can't have a choice. You have a bad case. I mean,
No, I'm only saying this.
we immediately sprang from our seat when we saw the order. It was highly undesirable for such kind of an order staying the operation. This is something which I'll get to you. We have heard Ms. R. Devi, learned advocate for the petitioners slash Union of India and three others, and Mr. R.B. Pukin, learned senior advocate for the respondent. By the impugned judgment passed by the tribunal, the transfer of the respondent from Gauhati to a different zone at Hazipur has been set aside. The respondent is a member of Indian Railway Service of Engineers. Who was made accused in a serious corruption case at the behest of the CBI. The charges against him were of criminal conspiracy and bribery, as also offences under the Prevention of Corruption Act. The respondent had been arrested. We don't want to put in all these things in the order. In fact, if you agree, we will only say that now this order has lost force. 3 years have passed by, that is the ground. Because we don't want the person, we are not concerned, otherwise we'll be writing everything against him.
I will utilize my knowledge limit acceptable.
We'll be writing so because we have to justify our judgment also. No? We'll be commenting on the tribunal. If you want, we have no difficulty. We'll be holding all this. That you were first given low risk posting, there was no malified intention. It was thereafter, then the tribunal entered into the confidential files and the railway board's directions were not perused. And then this order was passed. And because of the entering orders, you remained at that place, which was absolutely unfair to the railway administration, your employer. And for all this, we would also recommend, of course, it will be beyond our remit, we will recommend that a disciplinary proceeding should be initiated. No, this is something we will have to write. How to come out of this? That is the only difficulty. She can't withdraw this petition.
It will say something.
Let me try. I'll be least abrasive because I'll try and be least harmful to you while passing. Correct. Take that. As far as possible, I'll try and not be. I mean, we will not say anything which will further trouble you in future. Now, what did I say? Take your seat. Take your seat. It's great. Now, who was made accused in a CBI case involving allegations of conspiracy, bribery, and offences under the Prevention of Corruption Act. The respondent had been arrested, but was released on bail. While he had been facing criminal case, he was placed under suspension, which also was revoked after some time. However, the respondent was given a non-sensitive posting in the planning department at NF Railway headquarters in Maligaon, Gauhati. According to the petitioner, this was done in accordance with the railway vigilance rules, which provide that officers under the CBI investigation ought not to be kept on sensitive positions, as they would be in a position to influence the work or contracts. It further appears from the records that the Chief Vigilance Officer of NF Railway sent an advisory to the Railway Administration that the respondent ought not to be allowed to continue on any post whatsoever in the NF Railway zone at all, and that he should be transferred to a distant railway zone and also be kept on a non-sensitive post. Ms. R. Devi, learned advocate for the petitioners, has submitted that this kind of an advice is a standard in Indian Railways, where an officer has been made an accused in a corruption case. The purpose is not punitive, but only for the reason of protecting the integrity of the system. Protecting the integrity of the system. It can be likened to a preventive administrative step. Based on such advisory, the Railway Board permitted the respondent to be transferred to a different zone. The permission of the Railway Board was necessary because of interzone transfer of a Group A officer. The Railway Board had actually passed the order, transfer order, on 16th of March 2022, which order was based on an assessment of the entire set of facts, including the vigilance report, the administrative needs, etc. The respondent was transferred to East Central Railways at Hazipur. The NF Railways had promptly issued the relieving order also, for him to join the new place. The records reveal that the respondent challenged this transfer before the Tribunal Gauhati, before the Central Administrative Tribunal Gauhati, claiming that it violated the Indian Railways transfer policy of 2015, giving a minimum tenure to an employee on a post. The contention of the respondent before the tribunal was that the second instance of inter-railway zone transfer was a second transfer on the same grounds, which was done way too quickly, and the same has caused huge hardships to him. The tribunal, agreeing with the contention of the respondent, set aside the transfer order as also the relieving order. on the ground that the employer / railways could not have transferred the respondent within such a short span of time, only for the reason of the CBI case, only for the reason of the pendency of the CBI case, especially when it was against the transfer policy of the railway employee. Ms. Devi, learned advocate, while assailing the aforementioned order passed by the tribunal, submitted that transfer is an incidence of survey. And in this instance, such interzonal transfer is a standard policy, was in deference, it was in consonance with the, what did I say? Was in consonance with the standard policy of the railways in cases of such officers who were under CBI scanner for preventing the integrity of the system. It was further argued that the tribunal went beyond its remit in interfering with such transfer, which was made on pure administrative and vigilance grounds, and there was nothing on record to indicate any malafide. The transfer policy of giving a minimum tenure to an employee had to be seen in the correct perspective, especially in cases where the employer when the employer was of the view that allowing the respondent to remain anywhere in the same zone where he had been facing criminal prosecution would not have been good for the system. It was the interzonal transfer of the respondent only served the administrative needs. It has also been pointed out by the petitioner, by the learned advocate from the petitioner, that because of the interim order of stay and because of the interim order passed by the tribunal before disposal of the OAs, the respondent remained at Maligaon for more than the regular tenure of an officer at a station. Seen in this perspective, we find that the order passed by the tribunal was absolutely unjust and is fit to be quashed. We have also taken note of the arguments advanced by Mr. Hupen, learned senior advocate for the respondent, that the vigilance advisory was not for any particular zone, which choice was never indicated, and that the respondent had already been placed on a non-sensitive post at Maligaon. it was not because of any deliberate attempt made by the respondent that he remained at the post at Maligaon because of the pendency of the present litigation. Be that as it may, since the primary ground for interference by the tribunal with respect to the transfer of the respondent to a different zone was on the ground of violation of transfer policy, giving very small tenure to the respondent, which ground now stands erased because of the respondent having stayed at that place of posting for more than the normal tenure, we have chosen to set aside the order on more than one ground, namely the order being bad in law and the other that it has lost its force. The writ petition is allowed. The composite order passed by the tribunal in 2 IA numbers so and so are set aside. It will be open for the we leave it at that. So, since we have promised you that we'll be as less abrasive as we can, we will leave it.
I'm extremely grateful for that kind consideration. Only on facts, my lord, I was released on 13/4/22. So the order, I was actually neither here nor there. On 13/4/22, I stood released. That order is anyway been filed here also. That is all I wanted to indicate.
We are absolutely, I mean, it's with great disgust that we have dealt with it.
I'm extremely grateful for your lordship's kind consideration.
You would have said that transfer him immediately. We don't want to do that. We don't want to exceed our jurisdiction.
Item 48.
In this case also, we have filed caveat. Caveat is numbered as 385 of 2026. It is not tagged with by the registry law.
Where is Mr. Chaudhary?
No, my lord, actually, I have to file the petition afresh, my lord. There are some defect in the, my lord, petition. There are some defect in the petition, my lord.
But there are
There are
three
defects.
affidavits are missing, madam. It is
Because the statement of the
What do you
appeal does
want?
not tell you the,
What do you want?
my lord, we have silent the order passed by the,
I think he wants to incorporate, bring on record his affidavit, which are not part.
yes, my lord. Yes, my lord.
So bioweapon petition and appeal.
No, my lord, because if I,
Forget about the because.
my lord, my lord. My lord,
Even if
My
you
lord,
stand before the
my lord, my lord,
conducting the charge is not clear. in
My
this
lord,
report.
my lord, my
You want to bring on.
my lord,
Say that.
my.
I'm sorry to interrupt.
But-
Even in the paragraph also it is mentioned wrongly, madam, inside the paragraph. So that cannot be.
The
rectified.
documents does not,
What is your name?
A Ali, my.
Huh?
A Ali.
Mr. A. Ali, learned advocate for the appellant. Seek some time to amend the memo of appeal
My.
for the reason of many important documents having been left out, which would have an important bearing on the decision of the case. As prayed for, let this appeal be listed under the appropriate heading on after July, after August.
The caveat filed by the respondent number 6 may also be connected with.
Your name is
No, it is not there.
But my name is on respondent number
Respondent number 5 is filed
The name of the caveator also shall be printed in the cause list from the next date.
In fact, also the caveat is not connected. Caveat is not.
Okay, we record your name for the respondents give it.
Give your name for the respondent. Why, give your name for the.
SK Das also. Registry may be directed to list the caveat also along with.
This can be recording your name. Taken in the.
What is the?
Also memo appeal has not been served to me.
I'll
39.
Obliged.
Item 49.
You respond to this. Yes. If you respond to this petition, we have followed, there is nothing in this matter. You respond, he wants some time to repay the debt. Just take instructions, otherwise we can't help. Mr. M. Sharma to respond to this facility. Take oral instructions and tell us, otherwise we'll discuss. We can do it even today, but then leave it for. The petitioner by the aforementioned petition seeks some time from respondents number 2 and 3 to clear the outstanding loan amount. It has also been submitted on behalf of the petitioner that with such assertion made by him, the e-auction sale notice be cancelled. Such a prayer cannot be allowed. However, on the issue of repayment of loan, Mr. Sharma Leonard Counsel for the respondent bank shall take instructions and report back to this court by the next day. We notify after 2 weeks.
Obliged.
29-7. Item 50.
No. No. May I submit my?
One second, Ms. Court. Which is the other division? You could take that one. One to you. Okay. Who is my? He is Quran. All that. You can rest too.
Yes, Lordship.
Let this case go out of our list. No. We are sending you, Justice Surana cannot take up this matter.
Yes, Lordship.
Let this matter be listed before the special division bench, comprising a special division bench, preferably on. You keep it in July,
Yes, Lordship.
preferably on 20th of July. Interim order, if any, shall continue.
Interim orders, records, both the records are here.
This further matter, lot of evidence and other things have to be gone into. It's the benches are fully equipped to deal with all such.
Item 43 for hearing.
So in this matter, my learned friend M. Sharma is on left lordship. And also his name is not reflected in today's court list lordship.
Who is to address us?
M. Sharma.
Mentioned, it has been mentioned before us that this case is to be argued by Mr. M. Sharma, whose name has not been shown in the court. Even otherwise, he is on legs. Let the name of Mr. Sharma be shown in the court list henceforth. Let this matter come up under the same heading on your date.
No, it's been pray for an earlier date, Lord, because its matter is of 2018. The issue is of 2008.
Next week,
Yes, Lord.
maybe next week, the same day, Monday. Today is Monday. Next Monday,
Lordship, maybe on Wednesday.
on Wednesday.
Yes.
Highly obliged.
Of course.